prosecutor did indicate that there was information available to them from someone who had known Mrs. Silvera for a considerable period of time. And that person and Mrs. Silvera would have what she calls tracing, and by tracing sentiment make up some noise. The prosecution also had information that Mr. and Mrs. Silvera would often have arguments, but they would call and make up later. And even in that context, the deceased would still push her point. She was very determined and excellent, according to this individual. Indicate that she was a loving mother to her children. And the prosecution also had information that Mrs. Silvera was very mouthy, and what was meant by that she was feisty and a strong-willed woman who was very smart. So that was information that the prosecution had in its possession, which they indicated to the court. And so that is part of the context now in which the plea for manslaughter to manslaughter was considered by the court. And certainly, in my view, what Mr. Silvera indicated as to how the argument developed is not inconsistent with what these other persons are saying. This is not a question of maligning the dead, but it is what it is. And the information is from persons who are, or some of, at least two of them are friends of the deceased woman and who knew her apparently quite well. So that is the additional information and context here. Now, I'm going further now into the sentencing process. This is now part 3. Sentencing is a complex process. It is a multi-layered and multi-factored process. There are factors relating to the offense itself which must be considered, and matters relating to the offender, and both interact. And there must be someone that appropriate sentence. It has also been said that sentencing courts must keep in mind what has been described as the 4 classical principles of sentencing: retribution, deterrence, prevention, rehabilitation. The authorities indicate that the court also needs to keep in mind the character and antecedents of the offender. So, in other words, even if you are dealing with similar offenses, the sentences may not end up to be the same mathematically, because there may be factors that are peculiar to one defendant that do not apply to another defendant, even in the same case if they are convicted for the same offense. The level of participation and culpability may very well vary. So it is not surprising then in some murder cases, several persons can be convicted, but one person may be an accessory before the fact, another may be the one who did the act that caused death, and so on. So you have the variations there. Now, for voluntary manslaughter, which is what we are dealing with here, it usually attracts a custodial sentence, and the custodial sentence frequently, not invariably, frequently is higher than the sentence for involuntary manslaughter, if for no other reason that voluntary manslaughter is closer to murder in the criminal calendar. So that is how the reasoning goes. Remember that voluntary manslaughter involves an intention to kill or cause serious bodily harm and would be murder but for the presence of the partial defense, as in this case of provocation. It is also a serious violation of the victim's right to life. And so, for those reasons, it attracts a custodial sentence. The Criminal Justice Reform Act tells us that
Thank you for joining, Laura. Thank you.
In a manner to consider whether a non-custodial sentence is appropriate, but the same act excludes firearm offenses, and even if that statute had not been in existence, the general approach of the courts has been to impose a custodial sentence in cases of voluntary manslaughter. So we are getting closer, not yet there, but we are getting closer. So we now come to how sentencing is actually done. So since 2017, we have had sentencing guidelines, and I emphasize guidelines. It's not a statute. It's a guide. What is the purpose of the guide? The purpose of the guide is to establish a consistent methodology to the question of sentencing. It is not designed to produce mathematical equality. It's not what it's designed to do. So when you come to look at aggravating factors, there is no such thing as this aggravating factor equals 2 years, this other aggravating factor equals 6 years, this other one equals 0, this one is 10, and the mitigating factor, if this is present, it comes down by 6 months, it comes down by 10 years, and so on and so forth. It is designed to guide the thought process of the sentencer, who should articulate how he or she went about the sentencing process. So in the event, firstly, the defendant would need to know why he got the sentence that he did. Let's start there. Persons who may be connected in this case to the deceased would need to know how did the judge get here, even if they disagree with the judge and they go outside muttering afterwards that this judge is a real fool. But they would still be clear as to the process, as to how the judge got there. And also, in the event of an appeal, the appellate court would have the advantage of seeing the thought processes of the judge to determine whether the methodology and the approach is in keeping with established principles. So we have the case of the Queen against Misha Clement. That is been the cornerstone of our sentencing practice. In that case, the late President of the Court of Appeal, the Honorable Mr. Justice Dennis Morrison, referred to the Trinidad and Tobago case of Aguilera and the state. And for those who are really interested in this, it's found at 89 West Indian Reports at page 451. And in that case, or rather Justice Morrison referred to that case with respect and admiration. And he suggested that that case had adopted a more nuanced approach to the fixing of the starting point, because this is the anchor point in sentencing cases. What is the starting point? How do you get there? What principles go into establishing the starting point? So Trinidad was having the same issues that we were, some would say still are, having. And the Trinidad Court of Appeal looked at New Zealand and looked at other jurisdictions as well to deal with this question of a starting point. And after the examination was done, the Trinidad Court of Appeal decided that the starting point is defined in this way. That is a appropriate sentence considered appropriate for the particular offense of an adult offender after a contested trial. And that is the definition that I'll be using in this case to establish a starting point. Remember, it's just a start. The other thing is this, that this way of approaching sentencing, this method, this new methodology, is different from what was called politely the synthesized approach or the instinctive approach to sentencing, where the judge just simply heard from counsel and then said, well, I think it is worth 15 years, and that was the end of that. Nobody knew what the considerations were. That is now considered to be inappropriate in modern sentencing practice. But one of the sticking points has been the starting point. How is it defined? How do you establish it? And so the Trinidad and Tobago has contributed, at least to my understanding, by saying it is the sentence considered appropriate for the particular offense, an adult offender, after a contested trial. So immediately, since it's a starting point, it is rare that it is going to remain there. The approach of the Court of Appeal of Trinidad and Tobago, similar but not identical to that of England and Wales, and also the Cayman Islands, where they seek to establish as well a starting point. And what I'm going to do is to indicate that using the Trinidadian definition of a starting point, going to indicate now what goes into the considerations to establish the starting point. And then here I'm going to be using the terminology from the Court of Appeal of the Cayman Islands, where they use the language of harm and culpability. What do they mean by harm? It refers to the result. What happened? How bad is the result? What actually happened? It asks as well what could have happened, and culpability looks at the blameworthiness of the offense. Was it spontaneous? Was it premeditated? Those are the things that go into establishing the starting point. Now, there is something that is also a bit more controversial, and it has to do with how firearms are looked at. And here I must recognize the contribution of my judicial counsel, Mr. Blackwin, Shane Blackwin, who has been very helpful in doing the research in this matter. And in looking at the cases here from our Court of Appeal, there don't seem to be very many cases that seem to treat with firearm homicides as a unique or separate and distinct class. Other jurisdictions have done so. So one says use of a firearm, they say you start high. Why? Because it results in a death. And then now, so that's on the quote unquote objective side of it. And then on the subjective side now, you look at was it premeditated, was it spontaneous, and so on, to get a sense of where you should start. The other thing too is that the harm culpability approach refined in the Cayman Islands establishes categories. So within, for example, the offense of murder, you might have 3 or 4 categories, and each category has its own band. So for the offense of murder, you may find 4 bands. Band 1, this is the range of sentencing. Band 2, this is the range of sentencing. Band 3, this is the range of sentencing. They have also done the same for manslaughter, and they have broken it down now into manslaughter by provocation, manslaughter by diminished responsibility, manslaughter arising from an unlawful and dangerous act. And within each of those categories, you have bands within them. So again, it's not a one size fits all, because the idea is, while you recognize the seriousness of the offense, you also have to take into account the offender before the court to arrive at what is considered to be the appropriate sentence. So that is the approach that I'll be taking. And then when the starting point is established, then you look more closely at the aggravating, mitigating factors in this particular case. Then the next stage is to take account of things such as guilty pleas, previous behavior, good character, all of those things, and then you arrive at a final figure. So that's really the methodology. So from the research done, in Trinidad, as here, the maximum penalty for manslaughter is life imprisonment. One of the principles of sentencing is that maximum penalties are reserved for the worst of the worst, however defined. Some person may be wondering, well, How do you ever get there? Well, it's on a case-by-case basis. Some people are annoyed with that definition or approach, but there it is. So it is reserved for the worst of the worst. And the Court of Appeal of Trinidad and Tobago reminded us that even if the judge thinks that the penalties are low, the judge can't take it upon himself to say, well, in light of these low penalties, I am going to use the maximum as a starting point, because that is not the way it is to be done. So it is going to be very, very rare that the starting point is the maximum penalty in a manslaughter case. Notwithstanding that, the Court of Appeal in Trinidad and Tobago, they seem to operate in the range of 15 to 25 years for serious manslaughter. With regard to firearms, they give that special emphasis because, in their view, firearms are inherently lethal and create significant risk to the public. And accordingly, offences involving firearms in the Republic of Trinidad and Tobago are routinely placed towards the upper end of the manslaughter spectrum. And one case, Puran and the state, the court went as far as saying that where a firearm is deliberately discharged, substantial custodial sentences are justified, notwithstanding the presence of mitigating factors such as provocation or good character. In the Bahamas, that Court of Appeal there, they have identified a range of 18 to 35 years for serious cases of manslaughter. And they are of the view that manslaughter cases involving the use of a firearm should be to the upper end of the manslaughter spectrum. So too in Belize and also the Eastern Caribbean Supreme Court. So the sentencing methodology is not identical across those jurisdictions, but what seems to unite them is that firearm offenses are treated seriously and it elevates the starting point. Now, so I'm saying all of this to say that I'm not of the view that we're in Jamaica where we say that the range is from 3 to 15 is applicable here, since we did not and have not yet treated with firearm offenses in the way that other jurisdictions have. So, since we are dealing with voluntary manslaughter, it is the case that then it's a voluntary and deliberate act. And Mr. Silvera'S is not claiming that the gun went off. He's acknowledging that he shot her, but he's saying there was a presence of provocative words and actions. I also take account of the fact that certainly okay. We're going to pause a moment here, and I'm going to say this. So listen carefully now. No one is to have a cell phone or electronic device in their hands other than myself and counsel involved in the case and the journalists. No picture taking is to be done. So if you don't have it in your hands, the temptation is reduced considerably. Or better yet, switch them off. So no picture taking. Okay? Yes. So as I was saying that our approach, as in Jamaica, has not yet got to the point of Aguilera, what they've done in the Cayman Islands and so on. But nonetheless, let us make a start. This case is also taking place in a particular context. What is the context? That Parliament has indicated through the Firearms Prohibition, Restriction and Regulation Act that the use of firearms to commit crime, whether licensed or unlicensed, is a very serious matter, and they repealed the old legislation and gave enhanced penalties. Now, we have a range, as I said, from 3 to 15. So it will be quite a remarkable thing to me if persons who commit non-fatal offences with a firearm could end up with a higher sentence than a person who has committed a fatal offence with a firearm. So something just seems wrong about that. And so it is my view that in the present climate, reflected by legislative changes in other areas, homicide with a firearm could not be within the 3 to 15 range. It has to be higher than that. The other incongruity it would appear to me is this. The offence in count 1 charges the offence of using a firearm to commit a felony. Now, murder and manslaughter are not the only felonies that exist. Robberies are felonies. So again, you'll have the incongruous situation where a man who commits a firearm offense, in this case robbery, he may end up a longer time in prison because of the mandatory minimum, a longer time in prison than a person who has taken a life. So, that being the case, and having regard to what has been happening in other jurisdictions, how they've approached it, we look at the harm, a death, violation of the person's right to life, regardless of how provocative they may have been. The fact is, they have the right to life. And even persons on death row have the right to life. That is why the sentence is pronounced as to suffer death in the manner prescribed by law. So you can't have somebody running off the street and going on to death row and say, "Dear man, since you have been sentenced today, I'm going to save the hangman some trouble and I'm going to kill you myself." So that wouldn't be death in the manner prescribed by law. So it was a deliberate killing, because that's what voluntary manslaughter is. And so in my view, a starting point should really be, in this case, about 25 years. So that is where I anchor the starting point. That is in respect of count 2. The harm was significant, and the culpability, in this case, the offender, is the principal in the first degree. It was his act that caused the death. It was a deliberate and voluntary act. And that is also in the context of the movement to raise the levels of sentencing applicable to murder. So in my view, there should be a clear distinction between manslaughter and murder and wounding with intent. Yes, a very serious wounding with intent will maybe overlap with low culpability manslaughter. A manslaughter sentence at the higher end may overlap a little bit with the lower end for murder, but nonetheless, the distinction between the offenses should be maintained, and offenses that involve a homicide should always be regarded as a class apart from any other sentence, if for no other reason that the victim's, the deceased's right to life has been violated in a fundamental way, and it is an irreversible state of affairs. Then now, having established this anchor point, the starting point that reflects the gravity of the offense itself, reflecting its seriousness, the degree of harm, the level of culpability of the offender, then we go on to the next stage now of whether there should be upward or downward adjustment. And just to make the point that when you're dealing with upward adjustment as a result of aggravating factors, downward adjustment, mitigating factors. It doesn't mean that in every case there's going to be an aggravating factor or mitigating. So the judge is not to manufacture aggravating and mitigating factors. If none exist outside the commission of the offense, then that is it. So the judge can't go squeezing and torturing the evidence to find an aggravating or mitigating factor. Now, Now, in this case, we have had submissions from counsel on both sides, and I thank them for their assistance. I mean, I really thank them, not saying it because it's something to be said. So, we've also character witnesses as well coming into the defense. The Crown is emphasizing these factors that it says are aggravating factors. That is, Mr. Silvera would have known what happened. The Crown is also suggesting that Mr. Silvera has been before the court since 2024, early 2024, January 2024. So what he's saying is not really anything new, because he would have known about the argument in the bedroom. He would have known that he was the one who actually shot her. He would have known that she was either dead or dying when he left, and there is no evidence that he sought any assistance from anyone. You know, there's an accident at my home, please come. It was the discovery of the body by the children and the call based upon the narrative that brought him back to the house. So the Crown's position seems to be that he should not receive any discount because of the guilty plea, or very little because of the timing. And then, so we'll see what we make of that at the appropriate time. But that's the argument as I understand it. There's also a statute that regulates or has some assistance, provides some assistance here. This is the Criminal Justice Administration Amendment Act of 2015. And Part 1A speaks of reduction of sentence on guilty pleas. And in particular, it speaks to first relevant date, which means the first date at which a defendant who is represented by an attorney at law or who elects not to be represented by an attorney at law is brought before the court after the judge, magistrate, and this is the critical part now, is satisfied that the prosecution has made adequate, not complete, adequate disclosure to the defendant of the case against him in respect of the charge for which he is before the court. So the whole idea there of the legislation is that it is not the first day that you appear before the court, but what information did you have from the prosecution that will enable you to make an informed decision. And so the prosecution's argument is that disclosure was made in early January. Post-mortem examination was served as well. So they are saying, separated apart from what he knew, he also had information that outlined that it was his firearm that caused death of this person. And so the prosecution is suggesting then that the delay in entering a plea was, my words now, not theirs, playing the odds. Let us go along, see what happens, and then I will make a decision. So the prosecution is suggesting that this was a tactical move on the part of the defendant. And so the prosecution is suggesting then that this guilty plea, full as it is, should not, Mr. Silvera should not, from the generosity of the statute to the fullest extent. Well, we'll see what to make of that at the appropriate time, but the cases do indicate that a guilty plea is of value. What is the value? One, it minimizes, well, it removes the trauma of witnesses having to testify. It frees up resources so that it can be dedicated to other cases, and the person has accepted responsibility. So, if for no other reason, then it should be recognized as a mitigating factor. So, we have to weigh all of that. So in my view, in looking at this matter, what are the aggravating features? This is a killing in the context of a domestic setting. Mrs. Silvera was in her house. It is a place that she was entitled to feel that she could be safe, or at least not shot and killed. And the children have been deprived of a mother. So those are aggravating features. Another, to me, aggravating feature, because the narrative of the crown didn't indicate whether death was instantaneous or she was alive for some time. It wasn't clear on the narrative, but it means that if she didn't die immediately, then she would have been left there to succumb to her injuries. If she died immediately, based upon the narrative, these two youngsters, very young gentlemen, would have, as children normally do, you get up and you go into your parents' room. That's what children normally do, to stumble upon this there and leaving the children to make that discovery with no support. No, there's no evidence that any other adult was at the property And so they did what children do, you call the other parent. And then, when he came pretending that he was just as surprised as anyone else about the death of Mrs. Silvera. All of these, to me, are aggravating circumstances. In addition to that, let me get back to the narrative here outlined by the Crown in respect of the ballistic evidence. Because it was the ballistic evidence that anchored Mr. Silvera to the crime. So there's no report that the firearm was missing. No report that it was mislaid. No report that it was stolen. And his initial response to the police, granted, I will accept that the police officer had a responsibility. You can't be there being taken in by all of this. You go and you see a body. As a police officer, you're not a pathologist, but at the very least, you should be saying, don't touch the body. Call the crime scene persons. Let us see what happened here. So I wouldn't expect the police officer to be going over there pretending as if he's a forensic pathologist. It was misguided sympathy here. It was being taken in by the act of Mr. Silvera. To the extent that the police officer now, rather than doing his duty, he is now treating this as if it's just an unexpected death that may have been by a heart attack or some such thing. And during that, Mr. Silvera would have known that he was the person who was responsible for her death. The post-mortem says she got 3 gunshot injuries. And he was even telling the police officer that as far as he knew, she had no known medical condition that would cause her to be in the state that she was found, which is all the more reason why the police officer should have been far more alert than he was. And I had conduct of the matter when it first came for trial in February. And I will never say that a defendant cannot exercise his right to have the prosecution case tested. I have no difficulty with that. I have no difficulty with seeking your own forensic services. I have no difficulty with that either. But the fact of the matter is that when the matter came up, the defendant wanted his own forensic person, and that's fine. But it's in a context where you knew what happened. You knew. And when the forensic legal professional privilege, I won't get into that, but the fact of the matter is that it seems to me that the effort here was directed to see if there was some room to maneuver regarding the ballistic evidence, because that was the anchor of the prosecution case. And then after you had that opportunity, then the guilty plea came. So in other words, from December 2023 right up to February 2026, it was a state of denial, non-acceptance of responsibility. So that is going to inform how I view the plea of guilty. Context matters. So yes, you have accepted responsibility, but it seems to me that the acceptance came because of the quality of the work done by the Jamaican ballistic experts. And what is the expert saying? The expert is saying two things. One level of marking, you get the firearm category. Two, next level of marking, I keep using the word marking. Matching, you get the specific firearm. And he's suggesting that what he barrel was not the result of the natural processes of corrosion and so on, but a deliberate effort. And he's also suggesting that the impact would be that bullets fired after the interference may be different in its markings and so on to facilitate identification, different from markings before the gun was fired. In other words, we can't be sure. So that's how I come to it. And September 29, 2023 is a significant date. It shows the value of proper processes. The value of proper processes that the FLA did what it was supposed to do. You come to renew the license, give me your gun, let me look at it. Do I see any signs of tampering, corrosion, anything altering? Because one part of their responsibility is to keep signatures of all firearms of private citizens, so that the very thing that happened here, the police investigation can proceed and you identify the firearm. But the problem was, and here's the problem. The problem was the pathologist the fly in the ointment, because when the body was removed, that's from some cause other than violence. And it was the pathologist came along and said, what? No. We're going to deal with this differently now. It was her alertness. And based upon all the evidence, but for her alertness and professionalism, we wouldn't be here now. So that is part of the context for me. So those are the aggravating factors. Why are those things aggravating to me? Because it suggested an effort now to disguise, to cover up, to escape. And the science put naught to that. And when you had your opportunity to have your expert examine, no wriggle room. The expert, the Jamaican expert, couldn't be discredited. So we are here. Now, on the positive side now, mitigating factors, which must be taken into account. No previous conviction, clearly. Person of good characters, King's Counsel said, you were an elected representative. Some persons may believe that that is not necessarily a mark of distinction, but nonetheless, the electors of St. Mary found that you are a worthy person to represent, and that must be taken into account. There's no doubt about that. The evidence of your character witnesses, because as I've always said, if you have lived hitherto a previously good life, and when you get into difficulty, your good character cannot assist you, then what is the point? So yes, it has to be taken into account. The impact on the children, that is to say, the surviving parent will be a way to get to that point than others. And Counsel may very well point out all the rational arguments as to why they should do things at a particular time, but some clients just say that they ought to. There's nothing the lawyer can do about that, but you still have to work with the material that you have. So, Counsel referred to the Criminal Justice Administration Act of 2015, where it says, pursuant to subsection 1, the court may reduce the sentence that it would otherwise have imposed on the defendant in the following manner, where the defendant indicates to the court on the first relevant day that he wishes to plead guilty to the offense, the sentence may be reduced by up to 50%. Well, I don't think we're at the first relevant date. Let's go to part B, where the defendant indicates to the court at the first that he wishes to plead guilty, the sentence may be reduced by up to 35%. I think could say that he fits in there somewhere, where the defendant pleads guilty to the offense after the commencement of the trial, clearly not there. So where we are is paragraph B, after the first relevant date and before the trial commences. It says may be reduced by up to 35%. Now, what this provision is designed to do is to incentivize guilty pleas. But I suspect, and this is something now for law reform and the legislation, when you have the pairing of the offenses here of manslaughter, which the judge has more this discretion there with using a firearm, which is a mandatory minimum, then you wonder how does the defendant get the benefit of this? Because if you plead guilty at the earth date, it's a minimum of 20 years, and if you plead 12 months later, it's still a minimum of 20 years. So that has to be taken into account as well, because there's really no benefit, really, for entering an early plea where you have a mandatory minimum of 20 years. So so maybe the legislation should say something like, if he indicates on the first relevant date that he wishes to plead guilty, then notwithstanding the existence of a mandatory minimum, then the court can go below the minimum, because what you want to do is to incentivize persons to enter pleas rather than make it virtually pointless to enter, or you enter a plea. You can understand those considerations. But nonetheless, he entered a plea, and it is of value, and I've indicated what that value is. So that should result in a further reduction. I don't think it's going to be as high as 35%, because of the context in which the guilty plea occurred, but nonetheless, it is a value. So, and in this particular case, had it gone to trial, quite likely the crowd would have had to call the children to give the evidence. So that spared them the difficulty there, which is something that inures to his benefit. So again, there is no precise mathematics here, but in the context of this case, I think that is worth a further reduction of 4 years. That takes us down to 23. Now we're going to get into the percentage. We're starting at 35%. So that takes us now down to 23. This is in respect of count 2.
My name's Johnson.
Other factor is a question of remorse. It's one of those intangibles where is the guilty plea a reflection of remorse, or is it a tactical consideration? Well, I have indicated my position on that, and it seems to have been a tactical consideration rather than remorse. Though I acknowledge that he said in the social inquiry report that he's remorseful and all of those things, but having regard to the broader context, I think it was more strategic than remorse. But nonetheless, it's a guilty plea.
No, I have to want to prison, Bobby.
Nonetheless, he has been in custody for 2 years plus, so that's 2 years from 23 and 16 days. Okay, let's call it 25, 26 months. 26, let's call it 26 months. 2 years down from 23 and makes it 21. And then you take out the the 2 months, so that's 20 and 10 months. And then just checking to see if there's anything else that I need to bear in mind in terms of mitigating factors and their impact. And that seems to be it. I think that is it. Right. So, in terms of, we are at 20 years, 10 months, and that's the time for count 2. And instead of count 1, well, I'm just a trial judge. I am not at liberty to ignore the words of the parliamentarians, and they have indicated that there is a minimum and a maximum, and they have indicated that the minimum is 20 years, maximum is 25. So again, a guilty plea is of inherent value, whether it shows remorse or not. At least that's my view. And so I can't go below what Parliament has said. I know Mr. Champagne has referred me to the decision from the Privy Council, but they are the Privy Council. So I think that it would be improper of me to do that, not because council is inherently wrong, but I think it is something that deserves full argument, that all the circumstances surrounding the legislation and so on, all the relevant case law has been examined. It's very difficult to do that in the context of sentencing, and unless it's a clear authority from our Court of Appeal or the Privy Council to that effect. So, on respect of count 1, sir, sentence is 20 years at a minimum. So, the other principle of sentencing is that sentences arising out of offenses arising out of the same factual circumstances are to run concurrently unless there is some good reason not to do so. There is no good reason not to do so in this case. So both offenses, sentences on both offenses, count 1 and count 2, are to run concurrently. There's 20 years on count 1, 20 years, 10 months on count 2. And so, we are now happily at the end of this process. So, let me again thank counsel for the Crown and counsel for the defense for the work that they have done. And again, to recognize the significant work done by my judicial counsel, who at times I gave him things to do at very short notice. I know that he was up late at night doing the research, so I thank him again. So he has enabled me to be here this morning to do this. And just to, again, a gentle reminder to the media, please do your reports in a manner that persons, witnesses, or otherwise can be identified. Okay? So, That's it then. So let's adjourn. Yes. Should be stated. Oh, okay. Let's all sit. Have a seat. Yes. 101 of the new act. Yes. 101. 101 section. Okay. Okay. So I'm being reminded here that section 101 of the Firearms Prohibition, Restriction and Regulation Act says, among other things, 101 subsection 8 says, unless otherwise specifically provided in this act, the provided for an offense against this act is life imprisonment, notwithstanding anything in the act, the court shall specify a term of not less than 15 years that the offender shall serve before being eligible for parole. Well, that doesn't apply since the sentence for 14-2 is not life. And it says the alternative now is where there's a prescribed minimum,
Good day.
notwithstanding anything in the parole act, the court shall specify a term
Wrong
of
number,
not less
please.
than 10 years that the offender shall
Yeah.
serve before being eligible for parole. So I need to specify a term. Oh, well, okay. So anything on the, you have to give counsel a chance to be heard here, though.
Well, my lord, given the context in which, in terms of the plea, I would invite the court to invoke the minimum.
And 10 months in prison for the killing of his wife, Melissa Silvera. Of course, at 7 o'clock during our primetime news package, we will have comprehensive coverage, including interviews with the lawyers, both from the prosecution as well as the defense teams. We will have that plus reactions, hopefully, from the family. But that is for tonight in primetime news. I'm Janella Precious. We really have to go now.
No, you have gotten 20 years and some. Oh God. Ah, here ends the live, guys. See you later.